Good morning, everyone. Thank you for joining us for today's webinar. This is Rebecca Strauss. I'm joined this morning by my friend and partner, Andy Portinga. Hi, Andy. How are you this morning?
Good morning. How are you?
I am fantastic. We are here today to share some fairly good news with you about some new legislation that was adopted in Michigan here about a week ago now. There are some folks listening in on the webinar who are not from Michigan. The specific legislation we're talking about will not apply to you, but there are other things we're talking about today that might. So you are still welcome to join us and listen in. We are going to talk about generally the legislation for business liability and immunity, as well as some other risk mitigation information that you should be interested in. We're going to talk about, here's just the list, and we'll go through them one by one. New legislation, commercial general liability insurance, waivers, that was a hot topic a few months ago, whether businesses should have either employees and or visitors to their premises sign waivers of liability. And then we're going to talk about compliance and documentation, which you will learn is the basis for getting the immunity in the new legislation. So let's get started then. Andy, you want to kick it off with talking to people about what is happening in the world of COVID-19 litigation?
You bet. Thank you. So anytime we have a tragedy, lawsuits follow, and this situation is really no different. Right now, there are almost 6,000 cases nationwide that are related in some way to the pandemic. The number in Michigan is relatively low. There's less than 100 right now in Michigan that are COVID related, and a lot of the litigation in Michigan is not personal injury litigation. That is, what we're seeing in Michigan so far is a lot of litigation that is constitutional in nature, that is people who are challenging executive or administrative orders. We're seeing employment-related claims, and we're seeing insurance-related claims, particularly relating to business interruption insurance. But we're not seeing a lot of personal injury claims so far. That doesn't mean it's not going to come in the future. But it's perhaps not that surprising that we're not seeing a lot of personal injury claims that far, because I think it's fair to say that Michigan is not as favorable to plaintiffs as some other states, say Pennsylvania or Illinois or California or Florida. And there's a number of aspects in Michigan law that dissuade plaintiffs from bringing claims in Michigan. And so the statute we're going to talk about is another sort of barrier that plaintiffs have in Michigan to bringing personal injury claims, and particularly regarding personal injury claims that may arise out of a COVID-19 infection or exposure to COVID-19. So I think Rebecca is going to talk about the new statute and what it provides.
Yeah, thank you, Andy. Let's talk about the statute, which is Public Act 236 of 2020, a very fun name. This legislature decided not to give it any other name, so this is what we are forced to refer to it as. Let's talk about what it does. It's actually a very short law. Started off a little bit longer. We will bore you with the whole legislative history. Ended up quite short. It provides qualified immunity. We're going to talk on the next slide about what that qualified means. So kind of put a flag in that for a few minutes. Qualified immunity from a COVID-19 claim. First of all, let's talk about what immunity means. Immunity means anyone covered by this statute will not be liable for the things listed in the statute. Okay? It does not mean that someone is prohibited from suing you. Now let's break that down a little bit for those of you that may be confused right now. You have to litigate whether you are entitled to the immunity. Okay, so even if you are immune under the statute from liability for a plaintiff's damages, they may still initiate a lawsuit against you because they may argue that you're not entitled. to this immunity. So what I don't want you to do is walk away from this webinar saying or thinking, oh, we fit within these parameters, therefore we cannot be sued. That's not exactly accurate. You can be sued, you're just more likely to win the case, okay? That's what immunity is. You won't actually be liable. So what type of immunity does the statute provide? It provides immunity from tort claims. For those of you that have not been through law school, before I went to law school, I thought a tort was a cake. In law school, I learned that the tort is a civil action based on common law, essentially. In this context, we're talking about negligence, personal injury, that sort of thing. It is not a claim based on violating a statute. Okay, so this immunity law provides no coverage at all if someone says you have violated whatever statute it is, right, including employment statutes, by the way. Okay, we're talking about negligence and personal injury. It protects against claims if the claim is related to exposure or potential exposure to COVID-19 or to conduct intended to reduce the transmission of COVID-19. Okay, so that's when a plaintiff sues you, if you say, hey, Andy, Rebecca, right, I got to talk to you about this, I just got this complaint, could this immunity legislation help me? The first thing Andy and I are going to do is think about whether the plaintiff's claim is related to exposure to COVID-19. It does not protect against workers' compensation claims. The statute specifically carves out workers' compensation claims. So let's play that out for a moment and think about employee personal injury. Workers' compensation covers any sort of personal injury claimed from employees, right, if the injury or the disease in this case was contracted at work. So if your employees contract COVID-19 at work, their exclusive remedy is the workers' compensation process. This does not change that. Okay? They still can go get workers' comp. They can't sue you for negligence, but that was true even before this legislation because workers' comp was their exclusive remedy anyway. So this law is particularly relevant to giving you immunity from claims from visitors to your premises, right? Customers, patients, vendors, that sort of thing. Okay. It does not protect against government enforcement of statutes, regulations, executive orders, or agency orders. Okay, there is another statute, a new statute, which I'm going to tell you about that specifically impacts MIOSHA, but this one does not protect against government enforcement. So it provides immunity from private litigation. Why do we say the immunity is qualified? What do Andy and I mean by that? This immunity applies when the person, and we're going to talk about in the next slide what person means, so hold on to that if you just wondered what that means. It applies when the person acts in compliance with all federal, state, and local statutes, rules, regulations, executive orders, and agency orders related to COVID-19 that had not been denied legal effect at the time of the conduct. Okay, so lawyers love long sentences, and that's a long sentence. In plain English, it means that it only applies if you've complied with all of the various rules out there that are intended to protect people from contracting COVID-19. Okay? It includes the EOs that have recently been struck down by the Supreme Court. That's the purpose at the end of that long sentence. Okay, so if you were in compliance, back in April with whatever executive orders had been issued, as well as agency rules and federal rules, et cetera, you will be entitled to this immunity. Now, that may make some of you a little nervous because it is a very tangled web of laws and rules and regulations that we are all trying to navigate right now. and they are constantly changing. In fact, one changed right early evening, late afternoon yesterday, which I'll tell you about in a few minutes. They are constantly changing, and you are wondering, how confident am I, right, that my organization is in strict compliance with everything that's out there right now. So this law helps you tremendously with the next provision. So this is the second bullet point. But, and I put this in quotes because I love it so much, in isolated, de minimis deviation from strict compliance with such statutes, rules, regulations, executive orders, and agency orders, unrelated to the plaintiff's injuries, does not deny a person the immunity provided in this section. So that's really, it's really lovely. It's not as broad as you may want it to be because the violation has to be isolated and it has to be de minimis, which means small. But importantly, it has to be unrelated to the plaintiff's injuries. So let's say, there's posting requirements, for instance, for COVID-19 preparedness plans. And let's say you posted it in the wrong spot, right? You put it at some branches but not all branches, and not all employees and visitors could see it. And at a branch where it was not posted, a visitor contracted COVID-19. And let's just assume you were in compliance with everything else, and the plaintiff's lawyer, says, aha, right? I found a violation. I found something you were not in perfect compliance of. Well, that plaintiff would have to prove that the lack of the posting of the COVID-19 plan is what caused the plaintiff to contract COVID-19. We'll see how it plays out. You kind of have to see the facts and see the lawsuits that are filed, but I think it may be tough to prove causation in a lot of cases. Who is protected? It's a person. Persons are protected. Who is a person under the statute? It's very, very broad. Nonprofit charitable organizations, schools and colleges, individuals, actually any legal entity. Okay, I reviewed the folks who signed up for this webinar, and I didn't see any that made me think they may not be covered. Employees, agents, independent contractors, and volunteers even of a person are also covered by this immunity. So that's really good news. They defined the coverage very broadly in that context. The immunity is retroactive to any claim or cause of action that accrues after March 1st, 2020. So as Andy said, we're not seeing a lot of this type of litigation in Michigan so far. But if you or anyone you know has already been sued for a personal injury claim related to COVID-19, this immunity provides relief. Andy, who are the biggest beneficiaries of this immunity law?
I think it's fair to say that the biggest beneficiaries are the highest risk enterprises. And as Rebecca said, this statute doesn't stop a business or an enterprise from being sued, but it does create a hurdle, and in my view, it's a pretty high hurdle for the plaintiffs to get over before they can recover. And when we think about who the highest risk enterprises are, of course, there's a lot of focus on nursing homes right now because that's been a center of a lot of infection and unfortunately a lot of deaths. And this is definitely a benefit to them. Daycares and schools, now the data seems to be that young people aren't as affected as severely, and perhaps they don't spread it as much as older folks do. But that's an area where people are congregating, and certainly they benefit from this as well. Hotels and gyms. I'm going to the gym now, and I see people running on the treadmill, and I think of all the respiratory droplets being expelled every time somebody's on the treadmill. That's another area that is going to be protected or at least benefit from this statute. Bars and restaurants and theaters, pretty much any time people are gathered together in enclosed spaces, there is the risk of transmission, and enterprises that are businesses that have those kinds of environments are going to benefit from this statute. I want to talk, and if we go to the next slide here, I want to talk about what you shouldn't do. And Rebecca talked about the fact that this is qualified immunity. It's not absolute immunity, it's qualified immunity, and it means you can lose it. And the way you lose it is by thumbing your nose at the executive orders or the administrative orders and not trying to comply. And I took a picture. I've gone up north several times on the weekends this fall, and I've seen signs like this on certain restaurants and gas stations. I can only assume somebody's printing this off the internet. But the sign that I've seen in several places says, the governor has ordered all customers must wear a mask when entering this facility. If you have a medical condition that prevents you from wearing a mask, you don't need to wear one. If you're not wearing one, we'll assume this is the case. Due to HIPAA and the Fourth Amendment, we will not ask you about your condition. There's just so much wrong with this. First of all, HIPAA doesn't apply to a gas station or a restaurant, not unless they're providing medical services out in the back. The Fourth Amendment, same thing, doesn't apply to a restaurant or a gas station. And whoever wrote this has never read the Fourth Amendment. But this is a great example of how a business is going to get itself into trouble. Because if you're flaunting the rules, if you're not trying to comply, you're not going to benefit from the statute. Conversely, if you do comply, or at least you make a good faith effort to comply, you're probably going to benefit from this immunity statute. So if you're getting legal advice from the internet or from YouTube channels, you might want to think about whether that's really good advice. So hopefully nobody on this call has one of these signs in their business. If you do, please take it down.
Andy, you got me thinking of going for my next checkup behind the gas station. Let's talk real quickly about Public Act 237. There were three or four statutes that passed all at the same time. They were what's called tie-barred, which means they all have to pass or none of them do. This immunity statute is very similar to the one we just talked about, except this specifically applies to MIOSHA. Okay, this specifically applies to the Worker Protection Statute in Michigan, Public Act 174. And it's very, very similar to the statute we just explained to you. So you are not liable under that statute if an employer was operating in compliance with all federal, state, local statutes, rules, and regulations, executive orders, and agency orders related to COVID-19 that had not been denied legal effect at the time of the exposure. And again, they provide this very helpful exception, an isolated de minimis deviation from strict compliance with all of those rules that are unrelated to the employee's exposure to COVID-19 will not deny you that immunity. So you're good under the Worker Protection Statute as well. So that is obviously, these statutes are obviously very helpful to the business community in Michigan. But let's not forget, there's always insurance, right? Insurance has been here before COVID and it's still around. Andy, how does commercial general liability insurance help protect businesses in Michigan or anywhere?
Yeah, so this is another layer of protection. So we talk about the statute. The statute provides a hurdle that prevents or dissuades plaintiffs from filing lawsuits. It doesn't prevent them from filing the lawsuits, but it makes it harder for them to recover. Insurance comes in if you do get sued. And I want to talk a little bit about general liability insurance, which is different than business interruption insurance. There's a lot of litigation going on right now on business interruption insurance, the question being whether a business that had to shut down can make a claim under a business interruption policy. For the most part, there's hundreds of lawsuits across the country right now on that issue. And for the most part, that is not going well for the policyholder. The insurers are winning most of those lawsuits in most states right now. But that's different than what I want to talk about, which is general liability insurance, which is if somebody says, I got COVID and I got it from this bar or this restaurant or this business, under that scenario, your general liability insurance should come in and defend you in that lawsuit and potentially indemnify you for any judgment. General liability insurance covers liability for bodily injury caused by an occurrence, and an occurrence is defined to be an accident, that is, some unintended consequence to a person. And so, a COVID-related personal injury lawsuit should, in my view, fall within that coverage grant. Now, there are some exclusions to policies that you need to keep your eye on, although I don't think, frankly, any of them should apply to the current pandemic. A number of policies have a mold or bacteria exclusion, but of course, COVID-19 is not bacteria, is not mold, and it's not fungus. It's a virus. And so I don't think that exclusion should kick in. There's a lot of case law on the pollution exclusion, and the general liability policy excludes pollution-related claims. This goes back to the 70s and 80s when there was a lot more environmental litigation. I would not be shocked if some insurers try to invoke the pollution exclusion. The reason is pollution is defined to include a contaminant or an irritant, and I wouldn't be surprised if some insurers take the position that the virus is a contaminant. But frankly, I think that's well beyond what the intent of the pollution exclusion is, and I would be surprised if insurers are very successful in that defense should they raise it. So I think the takeaway here is that hopefully everybody has commercial general liability insurance, and that's one more level of protection that you have from any personal injury lawsuits. We can go to the next slide. We'll talk about waivers. And again, we've talked about different layers of protection. We now have the statute, the immunity statute. You have your general liability insurance, which is another layer of protection. And then we have the issue of waivers, and some businesses ask whether they should have customers or visitors sign waivers before they visit their premises. And I think, frankly, this is sort of a belt and suspenders approach. I think whether or not it's a good idea kind of depends on the business and really how practical that is. I know some gyms are requiring that. Perhaps a more high-volume business can't really do that. And I think it kind of is a case-by-case basis. A couple of things to keep in mind about waivers is you can't waive everything. You can't waive a workers' comp claim. And in Michigan, at least, a parent cannot waive pre-injury liability, a pre-injury claim for a child. You see this often in sporting events or daycares or the YMCA or gyms where parents may be asked to sign a waiver on behalf of their children. Well, in Michigan, that's not effective. And so the thing about waivers is it's probably not your first line of defense. It is sort of a belt and suspenders approach. And whether or not it's a good idea for your business probably depends on just the practical aspects of whether you can administer that or not.
Thank you.
Rebecca, you want to talk about compliance and documentation?
Yes, I would love to talk about compliance and documentation. So remember this qualified immunity, right? To get it, you need to be in compliance, right, with that whole laundry list of things. It doesn't actually name the statutes, rules, et cetera. It just says you have to be in compliance with everything. So here is the list as of today that are the most important rules and laws that you need to keep in mind to be in compliance with in order to qualify for this immunity. The latest MDHHS order, that's what we just changed late last night. On the slide, you may have heard that there was a new order that came out late afternoon. Frankly, it's good for many businesses. The subject of this webinar is not to go through that new order, so I'm not going to do that. But to summarize, there are new capacity limits for indoor and outdoor gatherings. There's new contract tracing requirements that cause a little bit of a brouhaha. Restaurants have to collect names and contact information. You can only sit 6 at a table in a restaurant now. I have a friend who has 5 kids, so now his family can't go out to dinner. But the most important thing really for businesses is the new order completely eliminated the workplace section that was in the previous order. So if you remember the order from October, I believe it was October 12th, and it had that whole workplace protection section, and frankly, it was extraordinarily poorly worded and confusing. It was called Protection of Workers, and it talked about gatherings and shared spaces, and we were all struggling to figure out what the heck that meant. And it had guidelines on close contact and when employees had to stay home and all of that good stuff. That has been completely deleted from the new order. So now we are just looking for those types of worker protections. We are just looking to MIOSHA, okay? We're not looking to MCHHS for those sorts of employee-specific protections. But there are other aspects of this order yesterday that you have to pay attention to. The limitations on gatherings, for instance, would still apply to gatherings in the workplace. Okay. The MIOSHA emergency rule, of course, it's obviously designed primarily to keep your workers safe, but a visitor to your business who got sick, I could see them trying to argue that you are not entitled to immunity because you maybe violated the MIOSHA rule, and that's why one of your employees had COVID, who then passed it on to the visitor, for instance. Remember Public Act 238 of 2020, I'm sorry, 236. All these, I just wish they would name the statutes instead of giving them numbers. It's 236 of 2020. That's the, no, sorry, it is 238. The immunity is 236. 238 is the one that talks about when employees have to stay home if they've had contact with someone with COVID, right, or if they themselves have COVID or have symptoms of COVID. We've done webinars on that. I'm not getting into the details of all of these. I'm just explaining to you the laws that you need to be in compliance with, the primary laws you need to be in compliance with to get this immunity. All right, don't forget about the FFCRA, an emergency paid leave, and then expanded emergency FMLA. That law is designed, right, to decrease the transmission of COVID-19 by giving people the resources and the right to stay home under certain circumstances. That is arguably, right, a law that would fall within this immunity provision. Let's talk about CDC guidance. The law does not talk about, guidance. It just says, rules, laws, orders, etc. So why did we put in here CDC guidance, which is just guidance? It's because the MIOSHA emergency rule requires employers to have a COVID-19 preparedness plan that is compliant with CDC guidance, with the most recent CDC guidance. Okay, so you do need to pay attention to that CDC guidance and make sure that your plan includes it as it changes, and that you're actually in practice doing what the CDC is telling you to do. Remember, just recently the CDC changed its definition of close contact. For instance, it used to be 15 consecutive minutes. Now it's 15 minutes over a 24-hour period. OSHA recommendations, exact same explanation. Your COVID-19 plan, according to MIOSHA, has to include OSHA recommendations. Okay? Remember to check your local county's rules. There are several counties in Michigan that have promulgated their own COVID-19 prevention rules and regulations. We're not going to go through every county on this webinar, but don't forget the counties. There are industry-specific orders. The most obvious is nursing homes and hospitals, but there are others. So if you have an industry that have specific orders that apply to you, please make sure you know about them and are complying with them. And as with everything we say in any of our webinars, please remember this is all subject to change because things keep changing. All right, last thing we want to talk to you about this morning is compliance and documentation a little bit more. How do we actually, I just went through all those rules and laws. How do you actually do that? And how can you help prove it later on? Okay, it's one thing to do it. It's another thing to get sued 6 months later and then a year later be in a deposition or exchanging documents and be able to prove that you were compliant with all of those rules and regulations. So first of all, obviously, keep records of all of your documents related to COVID-19 prevention. Keep records of all versions of your documents. And I know I don't have to tell you this because all of you on this call know. We've all been through many versions of COVID-19 preparedness plans, positive COVID-19 response protocol, the health screening changed because the law keeps changing and telling us what we need to include in those things. If someone sues you and says that they contracted COVID-19 on your premises on October 30th, 2020, and we're looking into this, next April, we need to know which version of these things was in effect at the time the injury occurred. So as you replace versions of things, keep the old versions, keep track of what dates versions were being used. That will be very helpful to you. Appoint one person who is responsible for doing that, right? Or else, frankly, it probably won't get done. It's not exactly a sexy part of the job, of anyone's job, to keep track of documents and put down dates about when they change, but someone's got to be responsible for that. Specifically, the law requires you to do this too. Keep records of all the trainings you're providing to employees. Remember the MIOSHA rule and executive orders before that. Required COVID-19 training of every single employee. It also required you to keep a record of the training. So keep a record of the PowerPoint slides, for instance. Keep a copy of the video if you're using our training video that we produce here at Miller Johnson. Keep a record of everyone who attended and the dates they attended. The law also requires you to keep records of the health assessments. Those are those daily health assessments, right? Asking if anyone has any symptoms or has been in contact with a positive case. There was a Q&A with the MIOSHA director a few days ago, which was surprisingly helpful. When you hear a Q&A or a webinar or something from the state of Michigan, sometimes they're helpful and sometimes they're not. But this one was great, and it's actually available on the internet. And if you need a copy, I can forward it to you. In that Q&A, the director made clear that you don't have to keep a copy of the actual form that the employee filled out every day, but you can satisfy this requirement by keeping like a log, right, of the date, all the employees who took the assessment and whether they passed the assessment or not. Okay, so that's really helpful. That was an open question there for a little while. By the way, when I'm talking about keeping records, it can be electronic. I often get that question. We're fine if it's electronic storage, just as long as it is somewhere. You may also want to consider an audit of your COVID-19 practices and compliance with all of those statutes and rules and regulations. Even outside of this immunity law, to be blunt, it's probably a good time to take a deep breath and step back for a minute and do that. We've been running around putting out fires, all businesses have, ever since mid-March. Everyone doing the absolute best they can, but it's not a bad time now that we've been in it for a while and now that we know we're going to be in this for another long while, right, to take a step back and take a more comprehensive look at what we're doing and what we might be missing and what blind spots we might have. And then we say repeat, right, because the laws keep evolving and changing. So even if you are in perfect compliance today, next week the laws may be different, right, and you may be out. So I can't tell you exactly how often to repeat, but if it were me, I would say monthly would be a good idea. We can help you with these audits, right, reviewing all of your practices according to all the different rules and guidance and everything else to help you feel more comfortable that you are compliant, or maybe more importantly, to help you see the holes and where you can fix them. I think that a letter, frankly, from Miller Johnson saying that you are compliant would be helpful if you were sued later, right? It would show you were in substantial compliance. That is all we had to say to you other than happy Halloween, the weird Halloween this year. But we hope you all have a safe and happy Halloween. I'm going to look to see if we have any questions now. Someone has asked for a copy of the MIOSHA Q&A. Absolutely, I'll send that out. Is there a differing guidance, MD, HHS, different from CDC, what is the prevailing guidance we should follow? So MDHHS is not guidance, it's a rule, okay? So that is the law of the land in Michigan. You should be following that as well as CDC. If CDC offers greater protections, had you go further than MDHHS, do that, right? Do the greater of the protections, and then you'll be safe. That these provide, the rules provide kind of the least amount of protection you have to provide to your employees and guests. You can always provide more. Does the new order still provide for museums, basically categorize museums in the same category as retail? That's a very specific question. I will get back to you, Mary, specifically on that after the webinar. With that, Andy, anything else you want to say before we let everyone go back to work?
No, thank you, everyone.
All right, thanks, everybody. Have a great day and a great Halloween. Bye-bye.